Let's dive into an essential topic for businesses navigating international waters: arbitration clauses. If your business is engaging in cross-border deals, understanding these clauses is a must. They're not just legal jargon, they're your safety net when disputes arise, saving you time, money, and a world of stress. Arbitration is an alternative to traditional litigation. Think of it as a private, streamlined version of court where you and the other party present your case to a neutral arbitrator or panel of arbitrators. The decision they make, known as an award, is binding. What makes arbitration shine in the context of international contracts is its flexibility and enforceability, which we'll break down further. When disputes happen, and let's face it, they will, arbitration provides a pre-agreed roadmap to resolve them without navigating unfamiliar court systems. That's a huge relief for businesses working across borders and where legal systems can vary dramatically in terms of efficiency, transparency, and fairness. One of the biggest advantages of arbitration is neutrality. Picture this: you're a Florida-based company partnering with a supplier in Southeast Asia. If things go south, neither party will want to fight it out in the other's home country courts. Arbitration allows you to choose a neutral jurisdiction or even conduct the proceedings virtually, leveling the playing field. That's huge. Confidentiality is another significant perk. Court disputes often become public record, which can damage reputations and expose sensitive business strategies. Arbitration, on the other hand, keeps everything behind closed doors. For businesses that prioritize discretion, especially in competitive industries, this is a game changer. And let's not overlook the speed of arbitration. Unlike litigation, which can drag on for years, arbitration is designed to be quick and efficient. While there are no guarantees on timing, arbitration generally resolves disputes much faster than traditional court cases. Here's where the real value lies. A well-drafted arbitration clause can be the difference between a smooth resolution and an even bigger dispute. It's not enough to simply agree to arbitration. You need to specify the rules, venue, and procedures up front. For example, will you follow the rules of the International Chamber of Commerce, or the ICC, the London Court of International Arbitration, the LCIA, or another institution? Each organization has its own set of procedures, and your choice will impact how the arbitration unfolds. You'll also want to specify the seat of arbitration, which determines the governing legal framework. Miami, Florida is a popular choice for parties in the Americas, for example, due to its accessibility and strong legal infrastructure for arbitration. Language is another detail you don't want to overlook. Imagine entering arbitration and realizing that the proceedings are being conducted in a language you're not fluent in. By agreeing on the language of arbitration in advance, you avoid this pitfall. While arbitration is incredibly useful, it's not a one-size-fits-all solution. One issue to consider is cost. Arbitration can be expensive, especially when you factor in the arbitrator's fees and administrative costs. For smaller disputes, these expenses can outweigh the benefits. Another factor is the finality of arbitration awards. Unlike court rulings, arbitration awards are binding and cannot typically be appealed. While this ensures a quick resolution, it also means you have to live with the decision, good or bad. Now let's talk about enforcement. Arbitration shines here thanks to the New York Convention, a treaty signed by nearly 170 countries. This means that arbitration awards are enforceable in most major business hubs around the world. If your counterparty refuses to comply, you can enforce the award through local courts in their jurisdiction, which is a huge advantage over relying on domestic court judgments. With advancements in technology, virtual arbitration is becoming much more popular. These options allow parties to conduct hearings online, reducing costs and logistical challenges. For international contracts, virtual arbitration can be a lifesaver, particularly when the parties are located on opposite sides of the globe. That said, virtual arbitration isn't without its challenges. Time zone differences, technical glitches, and the lack of in-person dynamics can sometimes complicate proceedings. However, for businesses, the convenience and cost savings outweigh these drawbacks. Different industries have unique consideration when it comes to arbitration. For example, in construction, disputes often revolve around technical specifications and project delays. Choosing arbitrators with expertise in the field can make all the difference. Similarly, in tech or intellectual property disputes, you'll want arbitrators familiar with the complexities of patents, trade secrets, or software development. For businesses in Florida, particularly those in sectors like construction or international trade, arbitration clauses tailored to your industry can streamline dispute resolution and protect your interests. One common mistake is being too vague in your arbitration clause. Simply stating disputes will be resolved by arbitration leaves too many questions unanswered. Which arbitration rules apply? Where will the arbitration take place? Who will serve as the arbitrators? Leaving these details ambiguous can lead to preliminary disputes about the arbitration itself, delaying the resolution of the actual issue. Another pitfall is failing to consider local laws. Even though arbitration is global, the laws of the seat of the arbitration can impact the process. For instance, some jurisdictions have strict rules about arbitrability, meaning certain disputes may not be eligible for arbitration. Working with a legal expert who understands both international arbitration and local laws is crucial. Arbitration clauses are an essential tool for businesses engaged in international trade and contracts. They provide a neutral, efficient, and enforceable way to resolve disputes, giving you peace of mind when operating across borders. But the key to unlocking their full potential is careful drafting. A poorly written clause can create more problems than it solves, while a well-drafted one can protect your business for years to come. If you're negotiating an international contract or reviewing your dispute resolution options, consider speaking with a business law attorney who specializes in international arbitration. It's an investment in your business's long-term success, ensuring you're prepared for whatever challenges may come your way. Remember, in the world of global business, preparation isn't just an advantage, it's a necessity. Thanks for tuning in, and if you have any questions about this or other legal topics, drop them in the comments below. Don't forget to like, subscribe, and share this video if you found it helpful. Until next time, stay informed and stay protected.